This series of webinars aims to help you advise your clients around housing issues that may arise for them after the UK leaves the EU. This video will take you through the EU settlement scheme. If you still have questions after watching this, you can contact Housing Rights Helpline on 028 90 245 640. In under 10 minutes, this video will explain the settlement scheme. It will look at the differences between settled and pre-settled status. It will cover applying to the scheme, options for Irish citizens and non EEA nationals. It will also define continuous residence, look at how periods of imprisonment may affect applications, and how a person might lose their status. The settlement scheme is the UK government's way of protecting the rights of EU nationals who live in the UK after Britain leaves the EU. European Economic Area nationals, or EEA nationals, and their family members should apply to this scheme to ensure their rights are protected after Brexit. Under the scheme, a person can be given either settled or pre-settled status. A person's right to access social assistance, such as housing and benefits, will depend on their status. Settled status is a type of indefinite leave to enter or remain in the UK. A person must have been continuously resident in the UK for at least 5 years to qualify for settled status. We will look at what continuous residence means later on. A person with settled status will have the same rights to benefits, housing, healthcare and so on as a British citizen, for as long as they have this status. A person with settled status can also apply for British citizenship as long as they meet all other eligibility requirements. Children born in the UK to a parent with settled status will automatically become British citizens. Pre-settled status is a form of temporary leave to remain in the UK. It can be awarded where a person has been continuously resident in the UK for less than 5 years. Pre-settled status entitles a person to remain in the UK for a further 5 years from the date the status is awarded. A person with pre-settled status can continue to live and work in the UK and to use certain services such as the NHS and education. However, pre-settled status alone does not make a person eligible to access housing and homelessness services or welfare benefits. A person with pre-settled status will still be subject to the same eligibility requirements that applied to EEA nationals and their family members before Brexit. They will usually be eligible if they are working, or if they have worked in the past but are temporarily unable to do so, or if they are the family member of a European national who is working or is temporarily unable to work. Generally, all EU and EEA nationals living in the UK should apply to the settlement scheme, including any EEA national who already has a permanent right to reside in the UK, and EEA nationals who were born in the UK. Children should also apply to protect their right to remain in the UK, and social workers should help children who are in care with this process. The following groups of people do not need to apply: any person with indefinite leave to enter or remain in the UK, any person with British citizenship, any person with Irish citizenship, although Irish citizens can apply if they choose to do so. Irish citizens don't have to apply to the scheme and can continue to live and work in the UK and access education, health and social security assistance without a need for any special status. However, an Irish citizen may have a family member whose only right to live in the UK is as a result of his or her relationship to this Irish citizen. In such cases, it's a good idea for the Irish person to apply to the settlement scheme so that family member can then make their own application. Recently, the courts ruled that immigration services must treat a person who was born in Northern Ireland and whose right to claim Irish citizenship is given to them by the Good Friday Agreement as a British citizen, unless they have formally surrendered their British citizenship. But the New Decade New Approach Agreement contains a commitment to ensure that the family members of people from Northern Ireland will enjoy the same rights as the family members of Irish citizens living in the UK. Non-EEA nationals may be able to apply to the settlement scheme if they are a family member of an EEA national. This can include great-grandchild under 21, grandchild, child, parent, grandparent or great-grandparent. A spouse, civil partner or a married partner of an EEA national, or a dependent relative of an EEA national. We've mentioned the term continuous residence when talking about the settlement scheme. Continuous residence means that a person has been habitually resident in the UK for at least 6 months of 5 consecutive years. Longer absences are sometimes tolerated. A person can be absent from the UK for more than 6 months but less than 12 months and still count this period of time towards their 5-year total in certain circumstances. These are pregnancy, childbirth, serious illness, studying, vocational training, or an overseas posting. A person simply has to show that they were actually living in the UK for 5 consecutive years to get settled status. They don't have to prove that they were working, studying, or otherwise exercising EU treaty rights. However, if the person's national insurance records don't show continuous residence through tax and benefit payments, the person will have to submit their own evidence to prove their residency. A period of continuous residence will be broken by any deportation order or any period of imprisonment. A period of imprisonment will end any period of continuous residence. This means that a person who has spent time in custody can only apply for settled status if they can show that they were continuously resident for 5 years before they were imprisoned or since they have been released. However, the EU settlement scheme also takes into consideration the suitability of a person when deciding whether to grant them status. This means that a person's criminal history will be considered when deciding what, if any, status to grant. For this reason, it's really important that any person who has a criminal record get advice and help to apply to the settlement scheme. People in this situation should contact the Stronger Together consortium, who can help them make an application. A person can lose their settlement scheme status. If a person with settled status is outside the UK for longer than 5 years, they will lose their status. A person with pre-settled status cannot spend more than 6 months in a row outside of the UK without breaking their period of continuous residence for the settlement scheme. They will not lose their pre-settled status, but this absence will impact on their ability to apply for settled status. Spending more than 2 years outside of the UK will cause a person to lose pre-settled status. Only certain people and organisations can help with immigration issues. You should signpost clients to Advice NI or Step Northern Ireland for help with the application process. These organisations will also help with challenging decisions. To recap, the settlement scheme is the UK government's way of protecting the rights of EU nationals who live in the UK after Britain leaves the EU. Under the scheme, EEA nationals can be given either settled or pre-settled status. Generally, all EU and EEA nationals living in the UK should apply to the scheme. A person's right to access social services, including housing assistance, will depend on their status. Signpost clients to Advice NI or Step Northern Ireland for help with the application process. If you are trying to help a client and are being told they cannot apply for housing or homelessness assistance, you can contact Housing Rights for advice on 028 90245 640. Visit housingrights.org.uk to keep informed of issues surrounding Brexit and housing. You will find news articles, our professional resource, The Housing Rights of Migrants Living in Northern Ireland After Brexit, and our series of webinars covering the housing issues that may arise once the UK leaves the EU. Signpost your clients to our public advice website, housingadviceni.org, where there is information specific to an EU national's housing rights after Brexit in 8 European languages, including English. If you would be interested in Housing Rights running an information session for your clients, get in touch. The information presented here is correct as of January 2020. However, there is still some uncertainty around the issues of immigration status. Follow us on Twitter or Facebook, or check back regularly to housingadviceni.org to make sure you are up to date on the issues that Brexit may have on your client and their housing situation.